Okay, can everyone hear me now?
Oh, we can hear you now. Is that what we were waiting for? Okay, we're ready.
Well, I apologize for that, Your Honor.
No problem. We're going to call the case. We are now live streaming on YouTube, and this is our second oral argument this morning by Zoom. This is Skanska versus MAP Mechanical. We are grateful to counsel for both sides who have agreed to present their cases this way. We will all be patient with each other as we work through this new way of doing business. The way we're going to proceed is each lawyer will get 5 uninterrupted minutes if he wants it, and we will follow those 5 interrupted minutes by any questions each justice has, and I'll try and turn to each justice separately so we're not talking over one another. This is a full grant, and each side has 20 minutes of oral argument. The time clock is also on the Zoom there, so everybody will know when 5 minutes is up, but I will try to organize our questions after the fact. So with that, Mr. Boucher.
Your Honor, may it please the court, Ed Boucher appearing on behalf of Skanska USA Building. We would also like to thank the court for its efforts in organizing this hearing, and we appreciate the opportunity to answer the court's questions. We ask the court to issue an opinion that holds there is no valid principle of law preventing insurance coverage for property damage caused by a construction defect. Instead, insurance coverage is determined by the contract of insurance itself, as that contract must be enforced under traditional rules of contract law this court has developed and issued through the ages. And when those rules of contract law are applied to the facts of this case, it's clear that the damage to the steam system at the Mid-Michigan Medical Center constitutes an occurrence under the insurance policy. That is the holding that the facts and the law entitled Skanska to. Now, when it comes to the topic of insurance coverage for construction defects, the bench and the bar of this state have strayed from the course. We have an errant branch of law, and this case gives the court the opportunity to prune that branch and to reinforce its traditional and very important and critical rules of contract law. Now, this morning I have basically 4 points to make, and I'd like to answer the court's questions. 1 point concerns our case, and 3 concern the issues raised by Amerisher. They are, first, under the proper method of analysis, the insuring agreement has been triggered under the facts of this case. It's that simple. Next, the court asked us to address whether the definition of occurrence in Hawkeye remains valid. In fact, it does not. And in fact, it's our position that the definition was never valid because it was based on faulty methodology. Third, Amerisher's fortuity argument does not withstand scrutiny. And then finally, the purpose of the insurance policy is dictated by the language of the policy itself, by the language of the contract that was entered into between the parties. Our first point, under the proper method of analysis, the insuring agreement has been triggered. As this court knows, a CGL policy is organized in such a way that a 2-step analysis determines whether or not an insurer must pay for the damage. First, has the insuring agreement been triggered? And if so, do any of the exclusions apply? Now, the exclusions are not before the court. The question before the court today only concerns the insuring agreement. Both parties have cited the insuring agreement in their briefs. I need not repeat it for you today, but in sum, it obligates Amerisher to pay those sums that we, the insured Skanska, become obligated to pay as damages caused by bodily injury or property damage caused by an occurrence. The term occurrence is defined by the policy itself as an accident. Accident is undefined by the policy, and therefore, under this court's longstanding rules of contract interpretation, we looked at the commonly understood meaning of the term accident. Now, what constitutes an accident is inherently a factual question. And this court's order granting leave asked the parties to address whether or not a question of fact had been demonstrated by the parties. I remind you that the facts of this case are undisputed. 3 of the 6 expansion joints installed by Skanska's subcontractor were backward. There is no dispute that Skanska intended them to be installed backward. There's no dispute that Skanska knew they were backward or even dreamed they were backward. It's undisputed that it took us more than a year to figure out the fact that these 3 expansion joints were backward. There's no dispute that our subcontractor, Matt Mechanical, intended to install them backward, or knew they were backward, or dreamed they were backward itself. In fact, all parties to this case, including Amerisure, agreed that these backward joints were nothing more than an honest mistake. That fact is undisputed. Now, on these facts, no reasonable juror would conclude that 3 backward expansion joints are anything but an accident and hence an occurrence under the policy. This ends the inquiry. The insuring clause has been triggered, and the trial court should have granted summary disposition to Skanska on this issue under MCR 2.116I2. It's really that simple and straightforward. Now, the complexity comes with all the issues raised by Amerisure. First, let's talk about the Hawkeye decision. This court, in its order granting leave, asked us to address the continuing validity of that decision. And as I said a moment ago, we contend that it's not only not valid now, but was not valid when it was first issued because it was issued on faulty methodology.
Counsel, I'm going to interrupt you here because we are beyond your 5 minutes, and I want to make sure that you have an opportunity to answer any questions my colleagues have. If you have time left over, you can reserve it for rebuttal. And I'll start because you're talking about Hawkeye right now. The defendant claims that if we were to overrule Hawkeye and the rule it has stood for a long time, it will do significant damage to the construction industry. Do you have any information about what effect, if any, the rulings in other states that have agreed with your argument have had in those jurisdictions? Is this cause for concern?
I don't see anything in those states that indicate that it's a problem. To be perfectly honest, I don't have empirical data on that either way, but nothing we've heard indicates that it is a problem. And honestly, this is something that the market itself will sort out if there is an issue in this state. Insurance companies are very skilled at setting premiums, and I'm confident that they will be able to set the appropriate premium as a result of this ruling. I'd also like to point out that the ruling we're asking the court to issue today does not mean that construction defects are going to be covered in every instance. There are still valid exclusions in the policy that will apply. All we're asking for is the court to enforce the contract as written, and when it does so, there are some construction defects that will be covered. On the facts of this case, it happens that the steam system was installed by our subcontractor, and that is not affected by your work exclusion that may otherwise apply.
Thank you. Justice Markman?
Yes, counsel, you indicate that the insurance industry is skilled and experienced in setting premiums, and I accept that. But aren't the premiums in this case premiums that were set on the basis of Hawkeye? A decision that's a fairly long-standing decision?
Your Honor, the premiums in this case are set by the language of the contract of insurance itself. The contract is ultimately what governs here, not the case law. Matt Mechanical purchased a contract, Skanska purchased a contract, and that's what governs. Amerisure is a big entity. It's sophisticated. It knows how to read contracts. In fact, it issued and wrote this contract. The premiums in this case are based on the contract, not case law.
Don't you accept nonetheless that in a case such as this, in which the law would arguably be altered, that there is at least some unfairness to the insurance company in terms of the fact in terms of the premise that it has been setting premiums based upon Hawkeye nonetheless.
Well, perhaps to a certain extent, but with all due respect to the insurance company, it has been issuing policies that say one thing and then acting under a different set of rules. We'd also point out that parties enter into these contracts and rely on the words of the contract themselves. These contracts are carried across state lines, and certainly the parties that the insureds relied on the language of the contract. And
is there any reasonable argument, in your opinion, to look at the precedent of Pohutsky, in which, in a case like this, in which the law was being changed in a significant way, it applied only prospectively? Is this, in other words, a Pohutsky case?
It is not, Your Honor. This is a contract case. The parties are entitled to the contract that they entered into. The language of the contract is pure and unambiguous. It says that when a property damage is caused by an accident, there is coverage. That is the language that applies. Certainly, Amerisure may not have priced its policy that way. It may have relied on Hawkeye. We have a degree of sympathy for them in that instance, but that's not what the contract says. And to answer your question about Pohutsky, we are looking for a ruling on the contract at issue between the parties today. What's at issue before the court is the contract between the parties today. It should apply today, not prospectively.
Thank you, counsel.
Justice Clement has a question about Hawkeye, so I'm going to turn to Justice Clement.
Thank you. Mr. Boucher, do we have to overrule Hawkeye, or is there a way that we can limit it?
I believe that Hawkeye can be limited. You'll notice that the Cypress Point case in New Jersey limited WEDO to pre-1986 policies. This court could certainly do that. We are not a big fan of Hawkeye because we think it employs sloppy methodology. It didn't employ the crisp rules of contract law that were in effect during its day. There's nothing in the definition of occurrence that is set forth in the Hawkeye decision that precludes property insurance coverage for property damage. That's in the exclusions that were in effect in the insurance contract of Hawkeye's day, just as it's addressed by the exclusions in effect today. So to answer your question, you don't need to overrule Hawkeye, but we're not a big fan of that decision, and we don't think it should really be regarded as carrying any weight.
Thanks.
Justice Zara?
No questions.
Justice Viviano?
Just to follow up on those two lines of questioning, I think where they may intersect, wouldn't it be better to overrule Hawkeye, or at least to address its validity in a case that involves the same contract language that was involved in Hawkeye? And I guess as a second question, I'll let you address both, or second point. Isn't that the reason, as you suggested, to the extent the considerations that Justice Markman raised should be considered, the idea of Hawkeye addressing different contract language would seem to alleviate some of that supposed unfairness, would it not?
Yes, Your Honor, you're absolutely right. The fact that Hawkeye concerns the 1973 policy rather than the 1976 policy is an excellent point, and that does alleviate the unfairness. I also agree with you that this may not be the right case to overrule Hawkeye per se, because the definition of occurrence did change in a very small way, and there may be a circumstance that requires the court to look at that definition. You do note that the intention and the intentional act exclusion that now appears as exclusion A in the CGL policy was originally part of the definition of Hawkeye. That's not at issue in our particular case. Those words are not implicated here because nobody contends that the backward expansion joints were intentionally installed. However, there may be a case where the court is called upon to look at the impact of that exclusion, and that would certainly be an opportunity for the court to look at it. But to answer your question succinctly, yes, the fact that there are two different contracts is a distinguishing factor that addresses Justice Markman's concerns about premiums and prospective effects. And yes, there may be a better opportunity to overrule Hawkeye, but it certainly can be limited today.
Justice Bernstein.
No questions.
Justice Clement, do you have any further questions, or are you satisfied?
I'm all set, thank you.
Justice Kavanaugh.
Yeah, I guess I just want to follow up on that same issue, that yes, it is that there's a, Hawkeye was dealing with a different policy, correct? And as you point out, there's a different definition of occurrence in the Hawkeye policy and then the 1986 policy. But, and I think I understand you to take the position that you don't think the difference between those definitions is not really material to the question, to the definition adopted, or the analysis adopted by Hawkeye, right? Because whether it's under the 1980 or 1973 policy and their definition of occurrence that contained the intentional act exclusion language, or the current occurrence, neither definition really supported the distinction that was relied on in Hawkeye about whether or not it's damage to the insured's own workmanship or damage to the property of another. So regardless of that, there is a difference, but it's really not material to the question here. And I think it's your position. I just want to clarify that while yes, there's a difference between them and we could distinguish Hawkeye on that basis, your position really is that the definition landed on in Hawkeye wasn't supported by the language under that policy either.
That's correct, Your Honor, on all fronts. The change in the definition is not a material issue in our particular case. What the definition in Hawkeye changed by moving that in known or intended by, whatever the language, I don't have it in front of me, excuse me, it moved that language over to the intentional act exclusion found in exclusion A. That's not implicated in our case today. The parties haven't briefed it. It really doesn't matter. And yes, that language makes no difference in the outcome of our particular case. It is interesting to note, however, that if a contract is to be construed as a whole and effect is to be given to all the language in it such that no clause is rendered nugatory, the intentional acts in the exclusion section means there must be some intentional acts that constitutes an accident or an occurrence under the policy. They must mean something. And that tends to undercut the fortuity argument raised by Amerisher. Exactly what that means, we don't know, because those aren't before the court today, and we haven't been asked to analyze the intentional act exclusion. It's not an issue today. There may be another opportunity for the court to do so at some point in the future.
Okay, I just have one more question, and I'm wondering if, do you think that they're assuming the definition that you are advancing for occurrence and that it's not tied to the ownership of the property that's damaged, but it's the intent was the result as intended by the insured from the perspective of the insured. Is there a difference, like say in this case, as you pointed out, that there were 6 expansion joints that were supposed to be installed in a particular direction. 3 were mistakenly, accidentally, however you want to say it, were installed backwards. Not intended, wasn't anticipated, this was not how it was supposed to be. What if the contractor intended that installation, saying, I think actually, so we've got these 6, 3 should be this way, 3 should be that way. And as it turns out, they're wrong. Is there a distinction between that when saying, this is what we intended to do, but something got messed up and it didn't get installed that way, or it got installed exactly the way that we intended it to, but as it turns out, that was wrong? Is there a definition? Are they both occurrences? Could there be a distinction where one is an accident and one is not?
The answer lies in the body of work this court did construing the meaning of the word accident. I refer you to the McCarn decision. We cite this in our brief, Allstate v. McCarn, 466 Mich 277. There's a passage in there at page 288 that addresses this issue. McCarn, as you know, concerned a shooting where somebody shouldered a gun, pulled the trigger, and killed someone. The court ruled that that was still an accident because the consequences of the act were not intended. The insured intentionally shouldered the gun, intentionally pulled the trigger, but didn't intend the consequence. And there the court instructed the parties to look at the relationship between the act and the consequence. And the court did that because analytically, every calamity that befalls humanity can somehow be traced back to some action by a human that caused or contributed to the calamity itself. Whether it be, in this case, intentionally installing the expansion joints in one direction because they believed they were to be installed that way, or unwittingly do it, or whatever. The point is that human actions have consequences. And the court has determined that whether or not these acts are accidents is governed by the relationship between the act and the consequence. And in McCarn, for example, I refer the court to this passage where the court wrote, in retrospect, a sufficiently diligent insurer could almost always determine the physical cause of an accident, tracing it back to some prior conduct by the insured that should have been performed differently. The court in that case was concerned that if we do trace it back to that extent, then we are really eviscerating these insurance policies here, because insureds could always do something differently, and insureds always begin their actions with some volitional behavior. And to do so really it doesn't answer the question. Remember, we impose liability because on the basis of fault. And you know, this court has held consistently that human actors, only a human actor's breach of a duty can be a proximate cause. Most recently in the Ray v. Swagger case. And that's what these insurance policies are for. The insuring agreement itself, going back to the contract, says the insured will pay those sums the insured becomes legally obligated to pay as damages. That presupposes a liability, some sort of fault that's at place here. So to answer your question, in this case here, if Matt Mechanical's crew somehow believed that these backward joints had to be installed in this way, is not really dispositive. What is dispositive is the relationship between the act and the consequence.
Thank you.
Thank you, counsel. Mr. Garish.
Thank you. May it please the court, Your Honor. Jeffrey Garish on behalf of AmeriSure. I agree with Mr. Boucher about one thing. The insuring agreement is the most important part of the contract, and it's the insuring agreement that is at issue here. And Skanska would have this court hold that any time a construction professional does a poor job or doesn't do the job that it contracted to do, requiring it to be redone or repaired and causing no damage beyond that, the liability insurer should have to pay the cost of that redo or that repair on the grounds that there's been an accident. Such a holding would be contrary to the fundamental purpose of liability insurance, contrary to this court's very well-established definition of accident, contrary to the majority approach across the country on this very issue, and contrary to public policy for several reasons. Such a holding would be a very bad idea, even if this court were writing on a clean slate. As it is, and as the court knows, the court is not writing on a clean slate, at least in terms of Michigan jurisprudence, because Hawkeye was decided and has been the law of Michigan for 30 years. I have to confess, I was a little surprised to hear Mr. Boucher say in response to Justice Kavanaugh's question that the material language has not changed. I agree with that. But in its application, Skanska argued that there was a material change in the definition of occurrence that required a different outcome with respect to the AmeriSure policy than was reached in Hawkeye. And even in his statement of question presented in his brief to this court, Skanska says that the dispositive provisions in the contract have since been materially changed. But he just conceded that they have not. And as this court's order pointed out, the issue the parties were to address is whether Hawkeye's definition of occurrence in the context of construction defects remains valid as applies to the language of the AmeriSure policy. It does. There's no dispute about that, and there's no question of fact about that. So I would submit that the court need go no further than to affirm on that basis. If the court is inclined, excuse me, to take up this request that Hawkeye be overturned, there are two very fundamental reasons why it should not be overturned. Number one, it's correct. And number two, there have been very heavy reliance interests placed on Hawkeye, as Justice Markman's question accurately noted. I'd like to address both of these, starting with the fact that Hawkeye was correctly decided. In fact, in some ways, Hawkeye was prescient in that the court based its ruling on the very definition of accident that this court would go on to adhere to in several cases. And it did so before this court really adopted and adhered to that definition, but it's the very definition that this court has applied repeatedly. That's the definition that was construed in Hawkeye. And the court correctly focused on the concept of fortuity, which is the concept that's most clearly implicated in the context of defective workmanship. Now, Skanska would ask this court simply to remove the requirement of fortuity from the definition, but a request that the court redefine the definition, which sounds like a request that the court not only overturn Hawkeye, but overturn all the cases that adopted this definition, is not well taken. Now, I can't help but note that this notion that the Hawkeye decision is an errant branch, as Mr. Boucher pointed out, contrary to McCarn, which he cites not only today, but also in his brief at length, that certainly would come as a surprise to Justice Kelly, because Justice Kelly, when she was a judge on the Court of Appeals, was on the panel that decided Hawkeye. She then not only was on the majority in McCarn, she actually authored the Frankenmuth versus Masters decision of this court that McCarn was based on. Justice Kelly recognized there's a fundamental difference between an intentional act, such as shooting a gun that someone thinks is empty, versus construction defect. Construction work is a unique context. And let me, if I may, quote a statement that this court made that I think is helpful. In a case called NEHRA, N-E-H-R-A versus Provident Life, 454 Mich 110. It's also an insurance coverage case. The court said this: words like injury and accident can have shifting meanings depending on the factual context and the area of law in which they're being considered. That's correct. And that's not to say that the word accident is ambiguous, but it does mean that context matters. And the context of this case is, as it is in Hawkeye, is a construction professional that is hired and paid to possess a certain expertise and preparedness and to exercise it. And Skanska's argument that any failure to possess the expertise, to possess the preparedness, or to exercise is an accident is just wrong. You don't even need to go to the fortuity component of accident to recognize, as Hawkeye did unanimously, that that's not an accident. That also happens to be the majority rule. The mere failure to do what you're contracted to do, what you're hired to do, is not an accident. And yet that is exactly what Skanska would have this court hold. So for example, if a contract professional is hired to install $100,000 worth of red tile and installs white tile instead, Skanska would say that's an accident because they didn't intend to do it. They intended to do the job right. Therefore, it's an accident. And to redo that tile is an accident the liability insurer should have to pay for. That is not correct, and it's contrary to the majority approach. The majority approach across the country, in almost every state that has decided this, is that defective workmanship that does not cause damage beyond the work of the insured itself is not an accident. That's correct. That's what Hawkeye held. That's what most courts have held, because they've recognized that if you're a contractor, you don't get paid twice. You don't get paid once by the contracting party to do the job right, and then a second time to do it wrong, rather, and then the second time to do it right by your liability carrier on the grounds that it's an accident. But there's a second very fundamental reason why this court should not overturn Hawkeye, and that is because the reliance interests are about as heavy as you can imagine in any precedent. Justice Markman, you're exactly right. Parties have entered into contracts, countless, innumerable, based on the law of Michigan that defective workmanship that does not cause third-party property damage is not an accident. That reliance interest makes the 17 Court of Appeals opinions that have relied on Hawkeye, and who knows how many trial court opinions have relied on Hawkeye, is nothing compared to the reliance interest that parties have placed.
Counsel, I'm going to interrupt you now because you are beyond your 5 minutes, and I want to make sure each of my colleagues has a chance to ask you any questions, but I'll start where you left off. The other states that have gone the way the appellant prefers that we go here, have there been, what havoc would be wreaked on the industry? I understand your reliance point specifically with respect to contracts that have been entered into under the Hawkeye understanding, but more generally, can you tell me more about why the industry seems to be able to absorb the reading appellant asks us to give here in other states, and why it would be different in Michigan?
Well, the industry will react to the situation it's faced with, of course. We don't have any empirical data, as was pointed out by Mr. Boucher, about states that take a different approach, much less states that have switched gears after precedent that's been on the books for 30 years. And that's the concern I have for the insurance industry. There are insurance contracts out there, who knows how many, they're countless, based on the understanding that defective workmanship is not an accident. So first of all, Justice Markman is exactly right. This absolutely is a Pohutsky case. So any change should be prospective only. We would submit the court doesn't even need to go there, but the reliance interest on these contracts is incalculable. And it's not just the contracting parties. I think it was helpfully pointed out by the Insurance Alliance of Michigan in their brief. There are a number of ISO forms that are occurrence-based. They attach 7 different forms, 7 different policy forms that are occurrence-based. So if this court is going to change the definition of accident, either changing its own definition or change the ruling in Hawkeye, it's impossible to determine what the consequences would be. We suspect that certainly one problem it would be remove incentive for contractors to take care in performing their duties. They would certainly have less, because they know if they make a mistake, if they have to redo the work, the liability carrier would pay for that. It would unquestionably make insurance more expensive and harder to come by. And it likely would almost certainly would increase the cost of doing business in Michigan. But if I didn't answer your question, please let me know, Justice McCormick. There's another important point here that we touched on our brief, but it hasn't come up yet. And I'll address it by saying, in response to Justice Clement's point, does Hawkeye have to be overturned in order for Skanska to prevail? Yes, it does, but much more has to happen. Even if you overturn Hawkeye, Skanska doesn't prevail in this case, because this case involves a very different situation. In Hawkeye, the insured sought coverage under its own policy for the defective work of its subcontractor. There are a number of cases across the country that have held that in that situation, where a general contractor seeks coverage under its own policy for the defective work of its subcontractor, that is an accident from the standpoint of the insured general contractor. But this case is not that situation. In this case, Skanska is seeking coverage as an additional insured under the policy issued to its subcontractor. So Skanska's coverage as an additional insured cannot be greater than the coverage owed to MAP for its own defective workmanship. That is what distinguishes this case from Hawkeye, and that is why Skanska should not prevail even if Hawkeye were overturned. Not a single one of the cases that Hawkeye has cited involved that situation. In fact, you'll notice that Skanska has not made any attempt to compile cases that support its position because and I feel that I may have failed in my brief to show how extreme the position that Skanska urges really is. In Home Builders Association's brief, they identified 25 cases that they said would find coverage here. That's their word. As a matter of fact, not a single one of those cases would find coverage here, not one. 9 of them involved damage to third-party property, damage beyond the insured's defective work itself. That's not the situation here. It's undisputed that the damage to the heating system was damage to MAP's own work.
Council, let me interrupt you to see if my colleagues have questions. I appreciate the answer. Justice Markman?
I do have one question, Mr. Garish. You expressed concern that if we were to undo Hawkeye, the response on the part of the insurance industry would be to raise premiums, which doesn't strike me as a totally illogical response on the part of the industry. But explain to me, please, if you would, how it's not only Skanska that is supporting reversal of Hawkeye, but also so many organizations representing the general contracting industry. Why would that be in light of the concern that you've, I think, not unreasonably expressed?
There's a couple of points, Justice Markman, and one, before I forget, one point that I think is very important to mention here is all of the amicus briefs, every single one filed in support of Skanska's application and in support of its brief, have focused on the context of a general contractor seeking coverage under its own policy for the defective work of its subcontractor. That is not the context that we have here. And in fact, I pointed that out in my brief, said that this is a different context. And I pointed out that the briefs filed by Michigan Infrastructure and Transportation Association and Associated General Contractors of Michigan focused on that. After my brief was filed, they didn't file amicus briefs to support Skanska's position. They have no longer have filed briefs supporting Skanska. They misunderstood the context. And even the briefs that have been filed now are all aimed at the notion that a general contractor seeking coverage under its own policy ought to get coverage for defective workmanship by its subcontractor on the grounds that that is not, that's an accident from the standpoint of the GC, which is a different context. In terms of why, I mean, it's no surprise, and I certainly, Amerisure is a Michigan-based company. Does not mean to diminish any the importance and merits of all the contractors out there. But having said that, it's probably no surprise that a contractor or an association or group would like to get free liability coverage for mistakes that they make when they do the job wrong. They have liability carrier pay them to do it right. It's probably no surprise that they would want that. But again, the majority approach, you don't get paid twice. You don't get paid twice. You don't get paid to do it wrong and then a second time by our liability carrier to do it right. Now, all those amicus groups are in good faith, but they're coming at it from a different perspective. And it's important to stress, there's really a disconnect between Skanska and the amicus groups. Skanska is seeking a truly extreme ruling based on its status as a GC seeking coverage as an additional insured, stepping in the shoes of the very party that committed the defective workmanship. On the other hand, the amicus groups are all focused on a different situation that is more like Hawkeye, but that is not the situation that's presented here. And if I can go back to the 25 cases, 9 of them involve third-party property. Yes.
We're running low on time, and I just want to make sure I get to each of my colleagues. Justice Markman, did you have any follow-up, or can I move on to Justice Zara?
No, thank you. I'm done.
Justice Zara?
No questions. Thank you very much.
Justice Viviano?
I have no questions as well at this point.
Justice Bernstein?
Yes, good morning, counsel. I just want to understand the logic here a little bit, and I'm really trying hard to follow it. Is it your position, I guess, your position that your opponent's arguing that there's no distinction between the kind of coloring of the tile, that if you were to lay red tile versus blue tile, that they would claim that to be an accident / occurrence? And I guess my question to you is that your position would be that you don't see any distinction between that and an incident such as this that caused sustainable and real damage. And I guess the follow-up question to that would be that, I understand the arguments that are going back and forth, but help me to understand, is this not the reason that people buy insurance, to protect from a situation like this where this is not just a cosmetic situation? It's not like a faulty road or a faulty workmanship issue, but it's something that actually sustained real and consequential damage as a result of the workmanship / mistake / occurrence.
Thank you for your question, Justice Bernstein. And Justice McCormick, I'm sorry, I didn't mean to cut off the questioning. The answer to your question, Justice Bernstein, is it's really not the purpose of liability insurance to guarantee the performance of the insured's work. It's the purpose to provide coverage for accidents that cause damage outside of the insured's work. It's undisputed that MAP was responsible for installing the heating system. So damage to its own work is not considered an accident, and it's based on the understanding in the industry that contractors and subcontractors are responsible for their own work. They're responsible for the repair and replacement of their own work. If there's damage to something other than that, then an accident exists, because that's not expected and that's not within the control of the insured. That's what most courts across the country have held, and they've recognized that distinction. You're right that there's a distinction on the tile example in that probably doesn't involve property damage, but make no mistake, under Skanska's view, that is an accident, because anything that a contractor does wrong that requires replacement or repair of its own work, under Skanska's approach, would be covered as an accident. Did I answer your question, Your Honor?
You did. Thank you, counsel.
Justice Clement?
No questions. Thank you.
Justice Kavanaugh?
Mr. Garris, I appreciate the distinction that there's a difference, or certainly has been the practice, or perhaps, as I think, as you said, the understanding in the industry, that there's a distinction between an accident from the standpoint in the construction or general contractor, subcontractor realm, and accident in the terms of, and therefore we're talking in those contexts under a CGL policy. I think the McCarn and those cases, Frankenmuth and that are accident in most cases, they're under homeowners liability policies, right? Not a general contractor, so perhaps different policies, but certainly different factual scenarios. And I can appreciate that there's a distinction, there's a contextual distinction in that. But what are we to do with the fact that AmeriSure and other insurers have decided to define occurrence in the exact same way? So while in a CGL policy that's going to apply in a commercial context or to general contractors and subs as additional insureds and the like, where they could define occurrence or accident, where it would specifically say that failure to perform what you have contractually agreed to do does not constitute an accident, or an accident is only damage when your work causes damage to a third, somebody else's property. It's not damage to your own. It could be defined to make that distinction, but Amerishare and other insurers have decided to apply the same definition of accident and occurrence across, you know, there is no distinction between the policies, and none of them specify what you're saying, whether it's tied to the contract or tied to the ownership of the property. What are we supposed to make with that when, while it may be an understanding in the industry that they should be defined differently, but if the language used in the policy isn't different, what are we supposed to do with them?
Right. As a practical matter, Justice Kavanaugh, the insurers rely on the ISO forms. And there's certainly, they use a lot of manuscript forms using their own terms, although usually they don't redefine core terms like accident. And it's tempting sometimes to look at a situation and a claim after the fact and say, well, if only you would have defined it differently, you would have had a better outcome. But it's a difficult thing to do in the context of insurance because you can't go back in time and redefine terms. And so the insurers have relied on the case law interpretations. They have relied on Michigan's 30-year-old case law that says accident is not met in the context. It's defective workmanship without more is not an accident. Not only in Michigan, but that's the law in most states. I don't think there's any principle that says if language could be clearer, that therefore it makes it ambiguous or it should prompt a different ruling. And it would be virtually impossible to carry out in the context of insurance because you can never know all the scenarios that are going to arise, whatever the type of policy. I don't know if that's helpful or not. Can I take another shot at it? Did I answer it, Your Honor?
Well, I think so. I think the difference, I mean, it's not trying to, I mean, this is not, you know, you could define it 8,000 different ways and hope that you catch 8,000 different fact scenarios. This is a CGL policy that is specifically issued to corporations that do that kind of work, as opposed to at issue in McCarn or the others that have to do with a homeowner's personal liability policy. So I guess if you're saying, well, like, you know, that we know that this means something different, I can appreciate that since Hawkeye, that has been the understanding for 30 years, is that damage to your own work product without more is not an occurrence. I guess my question, and maybe is that if that wasn't supported by the language of the policy in Hawkeye, what are we supposed to do with that? I mean, what if their definition tying it to this distinction between who owns the property, if it wasn't in the language of the policy in Hawkeye? And I understand your argument regarding fortuity and why it does exist, but if we disagree with that, how do we not overturn Hawkeye, I guess?
Well, you don't have to focus on fortuity alone. In fact, even if you look at McCarn, which I know, or Masters, which I know Brother Counsel talked about, and this goes back to another question that you raised, Justice Kavanaugh. McCarn, it says, unless the intended act created a direct risk of harm from which the consequences should reasonably have been expected by the insured. So now, even if you're focusing on expectation, you start with a proposition that expansion joints are installed incorrectly. That was done intentionally. They didn't intend to do it incorrectly, but they intended to do it the way they did. And that absolutely created a direct risk of harm. So even if you focus on that, and other courts have focused on the notion that the ordinary expected consequences of an act that's not an accident are themselves not an accident. Insurance Alliance cited the Viking case out of New Jersey that said this. I'm sorry, out of Illinois. The Bastille roof case that we cited on page 26 of our brief, footnote 10, applied Wyoming and Utah law, and they said the natural consequences of an act of defective workmanship are not an accident. And I guess to get back to your question, when courts, the majority courts are agreeing with Hawkeye and finding that this is not an accident, I guess it makes sense that an insurer is not going to use a manuscript policy to try to make this clearer. That's the best I can do.
Okay, thank you.
you, Council. Mr. Boucher, I'm afraid we used up all of your time when you first argued to us. So we are going to, the case will be submitted. I want to thank you both, Mr. Garish, Mr. Boucher. This helps us a lot in sorting through the important issues in this case. And we're grateful that you were willing to participate in oral argument in this format. We will be back on Zoom in our Zoom courtroom next Wednesday at 9:30. We're grateful again for everybody going along with the flow here. I will see my colleagues in our Zoom conference room in 5 minutes. Thank you, everyone.